allegedly mishandling and exercising a lack of professionalism during the recent Eron Kizza's case. The Uganda Law Society, under its banner of Radical New Bar Lawyers, were addressing the press today at their weekly briefing in Kampala. Macquarie University Law Don, Professor Christopher Mbazira, who was the keynote speaker, told the media they were shocked at how Kiiza's case was handled.
Guidelines that the courts apply, as much as the courts applying those guidelines as if they are the law, the courts need to remember that the right to bail is concretized in the Constitution. So they have a responsibility to actualize that right as protected in the Constitution. So in whatever they do, they should always remember they have an obligation to uphold the constitutional rights of the Ugandans.
Professor.
Mbazira warned lawyers about the crisis they are heading into given the presence of such abuse and disrespect of human rights.
Consistencies we see in that case is one, a very disappointing one is the reluctance of the court to accord the right of habeas corpus the status that it deserves, especially the first hearing of the court where the court declined to respect Kiiza's Eron's right of habeas corpus for the state to justify his intention, and somehow the court declines to.
Amos Kuku, human rights interest lawyer, celebrated Kiiza's bail, adding that the bail money, 20 million shillings, is exorbitant.
A human rights court and the court of equity is holding that it was uncertain as to when Eron Kizza's application appeal will ever be heard, because we don't know when Parliament shall enact such a law. He was convicted for contempt, an offense that didn't involve violence, if at all it even happened. Therefore, for all intents and purposes, there is unlikelihood that Eron would have scored or escaped from this jurisdiction, while the court of law retained his passport under the guise that if you want to travel, come and make this application. And on whose cost? If you're to hire a private lawyer, how much would it take for them to lodge that application? How long will it take for the application to be had? As such, it leaves a bad precedent as far as access to justice is concerned for the ordinary Ugandan and the general population. Those are bad precedents that we are retaining in the body of our case law. To lay some kind of a background about bail and these terms and conditions, we shall all recall that bail has been a subject of inconvenience to the powers in Uganda, calling on the judiciary to stop granting bail in specific cases. Actually, at time T, was a blanket call that we should legislate almost to abolish bail.
Kuku condemned the exorbitant bail fees requested by the courts from the accused, saying it's colonial and therefore needs to be scrapped to effectively dispense fair trial and access to justice.
Politically contentious cases, we shall recall that many times when accused persons are released on bail, they are rearrested, sometimes even within the midst of the court premises, and as such, many times court has stood helpless. It has happened so many times, including even the late Segeli.
Mary Goreti Nakamia, a lawyer, promised to educate the public via online means to seek and defend